Hi, it's Wednesday, February 11th, and I want to share with you a recent decision that we got granting termination of our client's removal case. This is an individual who previously had an in absentia removal order. And there's a long history here, one that probably applies to a lot of people, specifically DACA recipients who entered when they were young children with their parents. Now, this individual is one of you. She contacted me through TikTok. So if you're listening, you know who you are, and congrats again. She entered the United States as a young child, 11 years old or under, with a parent, and they were placed in removal proceedings. She obviously was at the whim of her parent, and they never appeared for their immigration proceedings. Mom or dad was probably handed a stack of papers when they entered, and essentially didn't know what they were, didn't follow up, and got a removal order in absentia. Fast forward, this individual now is a DACA recipient, has maintained lawful DACA protections the entire time, and is married to a U.S. citizen. Back in 2021, with another attorney, I believe, she filed and got an approved I-130. So her I-130 was approved in 2021. Now here is where it got a little bit complicated. Previous attorney had been retained to reopen and terminate the removal proceedings. But when I reviewed this case last year, it didn't actually look like anything was filed. Instead, what the attorney did is she requested that OPLA, or the ICE attorneys, simply join in to reopen and dismiss the proceedings. Now, this is something that wasn't necessarily wrong at the time. Under previous administrations, OPLA would join in on these requests, and they would affirmatively maybe reopen and dismiss. But after X amount of time of OPLA simply not responding, a motion could have been filed with the court, and that was just hadn't happened. So then the client contacted me and said, hey, what can we do? And I said, well, we can file a motion to reopen the in absentia removal order because it was, through no fault of your own. You were a minor child. You had no control over appearing in court, and we can show you have your I-130 approved. And I had explained that that's not technically what her prior attorney had done. She had just made the request with OPLA. So that's what we did. And the judge did not terminate it initially. The judge granted administrative closure, and that was an error. The judge had not read our motion in detail and thought she was going to be pursuing an I-601A waiver for unlawful presence. We explained she didn't need a waiver of unlawful presence because she had not accrued more than 180 days of unlawful presence. She had been a DACA recipient since prior to turning 18 and had maintained and renewed that DACA. Therefore, the judge granted admin closure, and we had to file a motion to reconsider and say, sorry, Judge, I think you're wrong here, very tactfully, and say, like we mentioned in our initial motion, we don't actually need a I-601A waiver. There's no unlawful presence accrued, and the appropriate remedy here is termination. And the judge sent us the order last week saying, you're right, there was judicial error, legal error, and therefore termination is warranted, and her case was terminated. So she no longer has a removal order, and she can now move forward with consular processing without a waiver and, continue this final step of becoming a green card holder that she's been pursuing since 2020. So I'm happy to be able to help her finish off this process. And it was a little bit nuanced of a case there that I wanted to share, but I'm sure is applicable to so many of you, especially DACA recipients.